give me a little bit of latitude, if you don't mind. There's sort of some breaking news here. Apparently, the D.C. Circuit Court of Appeals just affirmed the holding, I think it's Virginia versus Ferraro. Is that the name of it?
Yes, that's the name of it.
Illinois now.
Give me a second to set the stage, Mr. Chairman, if you don't mind. So you had two states basically sue in district court who ratified the ERA after the time period in question, compelling the National Archivist to enroll it in the Constitution. Is that generally what they were suing about, Ms. Foley?
Well, I don't know. I haven't read the opinion yet. Since
Illinois and Nevada brought a lawsuit in the district court.
Correct.
Saying their ratification after 1982
was
should
valid.
Count and get you to 38. And the district court said no. Is that correct?
That's correct. They sought a writ of mandamus to force the U.S. Archivist to publish.
So the district court upheld the idea that we, the Congress, could set deadlines, which we did in this case.
Correct, citing Dillon.
Okay. So today, the D.C. Court of Appeals rejected the mandamus request and upheld the lower court. So that's where we're at like 11 or whatever time it is. The point I'm trying to make is that the reason we're not starting over and we're trying to turn the Constitution, in my opinion, upside down is because if you started this process today, you wouldn't come anywhere near two-thirds of the House and Senate to ratify this amendment. And you all know that. Times have changed. Women's rights have been acknowledged. And why it would be so soundly rejected, this amendment would lead to chaos. This amendment would really punish women who are trying to play sports fairly. This amendment would give the court the ability to strike down every pro-life measure passed by the states. And if you don't believe me, this is what the NARAL said. Sent out a national alert. The ERA, what we're debating here today, would reinforce the constitutional right to abortion. It would require judges to strike down anti-abortion laws. Ms. Barkarius, do you agree with their position?
Yes, I do.
Ms. Sullivan, do you agree with their position? The NARAL is saying if the ERA were passed, become a constitutional amendment, it would allow courts to strike down all restrictions on abortion that exist in the states today based on the ERA.
Senator, I respectfully do not agree with that.
So you disagree with NARAL?
I do on that point, on that prediction.
Okay.
I think that there would be a case-by-case determination that would balance the right to women's equality against other rights, which is how we practice constitutional law every day,
right.
Senator.
The ACLU wrote the House in March of 2021. The Equal Rights Amendment could provide an additional layer of protection against restrictions on abortion. It could be a tool against further erosion of reproductive rights. Do you agree with that, Ms. Berceras?
I certainly do, and I mean, certainly that's what the proponents of the ERA
okay,
want
so
to
let's
use
just be honest. The people who are pushing politically to pass this are hanging their head on if it became law, every pro-life measure in this country would fall. You didn't say that in 1982. So if there's a law in a state, pick a state, that says a biological male cannot compete against females, would that law be subject to being struck down if the ERA is passed, Ms. Berceras?
Yes, it would. In fact, I would add that in my home state of Massachusetts, where we have a state equal rights amendment, schools are required to allow boys to compete in women's sports. And as a result, my daughter, who is now a Division I field hockey player, in her senior year of high school, her team competed against at least 3 teams that had more than 3 men on them, as is their constitutional right in Massachusetts.
So if gender identity becomes the new standard under restriction...
Oh, and this isn't gender identity. These were not trans-identified individuals. These were boys who identify as boys, and were very good athletes in hockey and lacrosse and thought, wouldn't it be fun or funny to go out and play field hockey against a bunch of girls, some of whom were future Division I athletes,
So I'll just
and
wrap.
take their spots on varsity teams.
Yeah, I'll just wrap this up, Mr. Chairman. The reason it wouldn't get 2/3 votes, most Americans don't like the outcome we're talking about here. Most Americans would be really upset to have a constitutional amendment that would do the things we're talking about. Mandate abortion on demand up to the moment of birth. That's what it would do. And the people pushing it, that's what they want. And if you can't pull this rabbit out of a hat constitutional exercise and count the states, not count the ones that rescinded, count the ones that did after the time period, and you had to start over, as Justice Ginsburg indicated, you would fail miserably. Because the times in which we live have changed. You wouldn't get anywhere near 2/3 vote in the Senate or the House because most members of Congress, and I think a majority of senators, do not want a constitutional amendment that requires abortion on demand up to the moment of birth. I think most members of the House and most members of the Senate, most members of the House and most members of the Senate would be offended by a law, a constitutional amendment mandating that biological males can take over girls' sports. That's why you would fail so miserably.
Fully ratified, and yes, Congress doesn't want that.
Have a good day.
Because Congress does not want to serve us. I understand that I need to be quiet. I understand that you do not like us to express our opinion, and that is why we still only have one constitutional right.
Goodbye.
So, if the senator from South Carolina, bear with me, I see this opinion that you've referenced in your statement, and as I understand it, the circuit court was affirming what the